So, hello everyone. Very warm good morning to all of you. So, this week is dedicated to the judgment analysis. Since we did certain legal current issues in the preceding week, and this week will be dedicated to
Very warm good morning to all of you.
the judgment analysis. So a very warm good morning to all of you, Chitralekha, Shalvi, and all of you who have joined and who are about to join. Okay. So the first case that I have taken up this week is a landmark judgment which has electrified debates across the length and breadth of the country. It's the hijab judgment from the Karnataka High Court. Srimati Resham versus the state of Karnataka and others. And on the bench of the Karnataka High Court was Chief Justice Ritu Raj Avasthi and Justice Krishna Dikshit and Justice J.M. Khazi. So good morning to all of you, Saksham, Soumya, Aditya, Nikhil. The date of the judgment is 15th March 2022. Now, on February 5th, 2022, the Karnataka government issued an order prohibiting students from wearing the hijab at state educational institutions with a dress code. The Karnataka High Court was then asked to review the order. On February 11th, the court issued an interim order prohibiting the wearing of all religious insignia in schools, including hijabs and saffron shawls. Now, before we begin with the facts of the case and heated discussion on this topic, I want to I want to pose this question to you. What do you think? Wearing of hijab is constitutionally protected, and if that happens to squarely fall within the ambit of fundamental rights, or it is a fundamental right, it is in itself a concrete fundamental right to wear anything you want, because it's about the freedom that is secured and guaranteed by the constitution of your country. What do you think that anything that replaces the fundamental rights or that replaces the freedom can sustain in a democracy like ours? Because it's all about democracy. We are living in a democratic state and we are the world's largest democracy. Now, basking in the unique status of world's largest democracies, having such controversies under the umbrella of or under the guise of being the world's largest democracy, this is something which has put our secular credentials and our democratic credentials in hot waters. So the question is very clear that on the one side it is about freedom, on the other side we have certain regulations drafted and framed by an authority, which may be a government or non-government organization. So the question is that what prevails in a democracy? Whether the freedom in a democratic country shall have primacy over any rule, any rule or regulation framed or drafted by any governmental or a non-governmental authority, or that rule or regulation shall have primacy over any freedom which is assured by any democracy. So what are the things that enjoy primacy in such cases? Okay, the question is very, very simple. It's a clear clash between the freedom and the rules and regulations of a society. Okay, now what happened that in Udupi and in Udupi city of Karnataka, this this issue came out abruptly and suddenly. It has startled the people around the country, in and around the country. Chitralekha says that I am a Hindu, but I studied in a Christian minority school, and in that case, I was never allowed to put mehndi or wear payal or any kind of jewelry or even put bindi for that matter. That is the question, Chitralekha. It's not about hijab or bindi. Let me be very clear. I'm trying to explain you that this case stands as a clear conflict between the freedoms guaranteed by the Constitution and the rules and regulations framed by the government. Because most of the times the judiciary had a stand in favor of the freedoms. In favor of the freedoms. Like judiciary has gone to an extent to protect these freedoms in cases where games like rummycircle.net have been allowed by the Supreme Court only because it's all about freedom. No matter what obsessions it's going to create, what harmful effects it's going to unfold, irrespective of everything, the Supreme Court has gone to the extent of recognizing these games as legal because it's all about the freedom of the people. I'm talking simply about the gravity and intensity of the freedoms in a democratic society. Okay. Aditya Prakash says that no fundamental right is absolute. That's very good observation, Aditya. No fundamental right is absolute. Certain rules and regulations are compulsory. Educational institutions must have a dress code. That's very good observation. But again, the question remains same. The question remains same, that if the fundamental rights are not absolute, then how far are we allowed to suppress them or muzzle them? That's the question. How far we are supposed to muzzle them? We are supposed to follow the doctrine of proportionality. There are two important doctrines which are involved in this case. One is doctrine of proportionality and the other is doctrine of essential religious practice, the ERP. And you must have come across this question of essential religious practice in your mock test also, because there was a question, I guess, on ERPs that it was evolved in which case? It was evolved in the famous it was Shrimat case of 1954. Okay, in 1954. Now that was evolved in 1954, essential religious practice. Okay, now these are the facts of the case. Very simple and straightforward. All of us know that. What is the Baat Jazbato Tum says, but dress codes are important and that is why they are followed. Yes, that's true. Now let us read the issues. Is the right to freedom of conscience protective of hijab wearing? Is wearing the hijab an essential religious practice under Islam? Is hijab ban in classrooms a violation of the right to freedom of expression and privacy? Is the ostensibly anti-hijab government order valid? Now these were the issues. Is the right to freedom of conscience protective of hijab wearing? Now, these are the questions that I was trying to raise in the beginning of the lecture, that you have under Article 25 of the Constitution. Article 25 of the Constitution, that is the repository of all the secularism we talk about in India. It's a repository. Article 25 gives us the freedom of conscience. Freedom of conscience means that we have a certain relation with God, and that is completely our prerogative. That is completely our call. What kind of relation we establish with our God? Nobody else, not even the state, is empowered to intervene or poke its nose into my relation with God. This is something between me and God, and this is what you call freedom of conscience. How do I perceive God? How do I worship Him? and how do I like look at him, through what prisms, is the freedom of conscience. This is freedom. This freedom is available to almost every person in India. Okay. Okay, now this is freedom of conscience. Freedom of conscience, freedom to practice, propagate and profess any religion. But this article starts with the word that subject to public order, health and morality. Subject to public order, health and morality. Subject to public order, health and morality. Okay, public order means that if any religious practice is defiant of any public order, it's disturbing the public order, it can be curbed. That's all right. If it is harmful of the general health of the society, then it can be curbed. If it is against the basic moral standards of the society, it can be curbed. Okay, so no fundamental right is absolute. Is wearing the hijab an essential religious practice under Islam? That's the most important issue in the whole case. Wearing the hijab is an essential religious practice under Islam, because if it happens to be an essential religious practice, then that means that forms the core of the religion, and then it cannot be suppressed. If it is not disturbing the public order, if it is not affecting the general health of the society, if it is not against the basic moral standards of the society, and if it also happens to be an essential religious practice under Islam, then it cannot be curbed. Is the hijab ban in classrooms a violation of the right to freedom of expression and privacy? Now that was the question, whether right to freedom of expression and privacy can be claimed inside the classrooms, or classrooms are qualified public places. Is the ostensibly anti-hijab government order valid? Now once these issues, the first three issues are solved, and we get a clear answer to all these issues, the answer to the fourth issue would automatically come out. Whether is this ostensibly anti-hijab government, ostensibly means that this order was actually came as a general order but its objective, it's a hidden and tacit objective, was to ban hijab specifically. So is the ostensibly anti-hijab government order valid? Now Prablin says that I don't have much idea about the stand of hijab in Islam. If it's not a practice which is the foundation stone, or without which the religion will lose its essence, then the ban on hijab is valid. Chitralekha says, but Prablin, are courts the right to place that recite matters of religion? That is the question, Chitralekha. That is a very genuine question. Judges are not experts of religion, religious heads are. That's very true. Now who is going to decide? The question is that who is going to decide that what is an essential religious practice of Islam? I am not a religious scholar. The judges who sat on the bench were not the religious scholars. They had no idea about any religion. How can they decide about the essential religious practice of any religion? Like in Hinduism also. Okay. Once the Supreme Court also declared that Tandav dance in Andhra Pradesh, the state of Andhra Pradesh, did not form an essential religious practice in the religion of Hinduism. Okay. Now the laws involved. Constitution of India. Article 19(1)(a), Article 25, Article 21, Section 133(2) of the Karnataka Education Act 1983. Now, arguments of the petitioner. The impugned government order dated 5th February 2022 is based on the incorrect narrative that wearing hijab is not an essential religious practice of Islam, and thus prescribing or authorizing the prescription of dress code uniform to students in accordance with the said narrative is a violation of their fundamental right to freedom of conscience and the right to practice their religious faith as guaranteed by Article 25 of the Constitution. State of Kerala versus Bijoy Emmanuel. Okay. What happened? You must have come across this. Did you ever read this this case of Bijoy Emmanuel versus the state of Kerala? have you ever read the facts of Bijoy Emmanuel versus the state of Kerala? Yes, national anthem case. Very famous national anthem case. This national anthem case में क्या हुआ था? There were 3 students who hailed from a particular caste in the state of Kerala, and as per the norms of their caste, they were not allowed to sing any other anthem or song other than their own religious songs. And so they were reluctant to sing the national anthem, albeit they used to stand straight and respect the national anthem in every morning's assembly, a school assembly. But once they were keenly observed by the teachers around them, they were given warnings, they were told to sing, they were asked to sing the national anthem in the chorus when it was being played. But they said that we stand straight, we don't disrespect it, we have a great respect for our national anthem, but we are not going to sing it because our religion does not allow it. Despite repeated warnings, they still remained reluctant to sing the national anthem, and finally they were expelled by the school authorities. The matter went before the Kerala High Court, which held that the expulsion of these 3 students was all right. But once the matter went before the Supreme Court said that right to keep silence is also a part of right to freedom of speech and expression, and right to freedom of religion was part of it. Right to freedom of religion, like their religion did not allow them to do that, so why should they be expelled for doing something which does not amount to any disrespect? If they were standing straight on while the national anthem was being sung, then it does not amount to any disrespect. This shows that they have great respect for the national anthem, but they should not be compelled. If their religion does not allow them, this is their freedom under Article 25 of the Constitution, and that is their freedom under Article 19(1)(a) to keep silence. Okay, so in what happened case, Puttaswamy versus Union of India, it's a case on privacy jurisprudence. An unfettered, uncompromisable right under Article 21 of the Constitution of India. It's about privacy. Then the states and schools' actions are in breach of the doctrine of proportionality, in that in taking the drastic step of prohibiting the hijab on campus, the viable alternatives that pass the least restrictive test have not been considered. Okay. Now what discussion is going on in the comment section? Chitra Lekha says, then one day all our freedoms will be defeated in the names of essentiality and proportionality and what not. Shalvi says, Supreme Court held that no person can be compelled to sing national anthem if he has genuine objections based on religious faith. Yes. Okay, so there is another debate initiated in the comment section. Now please listen to me very carefully. Listen to me very carefully. I'm not forming an opinion. I'm not giving a judgment, because I'm no one to give a judgment here, and I'm no one to comment on anybody's views, personal views. But as a democratic citizen of this country, I also have a right to put my views across freely and frankly. Is that the freedom that you assure me? Right? Every individual assures this freedom to another, because this is something which is protected under the umbrella of the Constitution. That is the shelter, that's the common shelter we share together as fellow citizens, isn't it? Now there is doctrine of proportionality. Now arguments of the respondent. Before we read about the 2 doctrines, let us read the arguments of the respondents. Arguments of the respondent: the fact matrix derived from the petition evidence lacks material particulars about the wearing of hijab at any point in time. The petitioner was trying to say that in Bijoy Emmanuel versus the state of Kerala, the religious freedom was given primacy over the rules and regulations of the schools. In justice case Puttaswamy versus Union of India, The Supreme Court upheld explained the gravity and intensity and depth of the right to privacy under Article 21 of the Constitution of India. And so, since we have so many judgments, and since we have these freedoms under so many articles of under Part 3rd of the Constitutions, so hijab should be allowed in and on the campus. Okay, that was the arguments of the petitioners. Now arguments of the respondents. The respondent says, as the state of Karnataka replied, that the fact matrix derived from the petition averments lacks material particulars about the wearing of hijab at any point in time. So there is no evidentiary material worth mentioning is loaded to the case record, even in light of the petitioner's meagre averments. The question of how long the students have been wearing hijab has never been raised. These kids did not wear a headscarf in the classroom or at the institution at any time. Regardless, the rights claimed by petitioners under Article 25 are not absolute. Now, the first argument, the first rebuttal of the respondents was, now Zinia and Taran have to say something. Zinia says, but why hijab is under scrutiny now? Before February 2022, also there were students wearing hijab in schools and nobody raised an issue. Can we consider it to be an unrest intentionally caused? Now answer, can anybody answer Zinia? Taran says, impinging upon the FRs has been the virtue of legislatures coupled with executive. Judiciary has always come to the rescue of our citizenry. This time, the judgment was not in the favor of the citizenry, Taran. Now that's a genuine question raised by Zinia. That is even my question. As a democratic citizen of this country, that is even my question what Zinia is trying to ask. Can we consider it to be an unrest intentionally caused? Why did not we talk about these issues before February 2022 or before, like some time back? We never had these kinds of issues in and around the colleges. But why now? The question is, why now? Now, as the respondent was expected, it argued that the fundamental rights are subject to reasonable legal restraint and regulation. In any case, girls in all girl institutions such as the respondent PU College, Udupi, cannot claim the wearing of hijab as a matter of right because it is undoubtedly an essential religious practice in Islam. Wearing a hijab or a headscarf is not an essential religious practice of the Islamic region. The Holy Quran contains no such injunctions, and the apex court has laid forth the rules for deciding what constitutes an essential religious activity. Right, Shri Lakshmindra Tirtha Swamier of Shri Shirur Mutt versus Commissioner of Hindu Religious Endowments Madras. Now this was the case from the year 1954 in which this doctrine of ERP was evolved. Okay. Now Taran says, but the only distinction that casts a line between February 22 and the present date is the hard fact that the earlier students weren't prohibited from entering the premises. Then why they were prohibited now, Taran? Why not from the very first day? Now, why not from the day when the institution is commenced its classes? They should have decided this rule and regulation from day one, that any student would not be allowed in any religious dress code. Any religious dress code is strictly prohibited. They must have issued this books on manual on rules and regulations beforehand. Why a sudden prohibition has come? That's what Zinia is trying to ask. That's what I'm trying to ask. Okay. Now let us read the judgment and then we can discuss the doctrine of proportionality and doctrine of ERP. After hearing the parties, the court decided. Issue 1. The court made a contrast between conscience freedom and religious expression in the judgment, noting that while conscience is an internal belief, religious display is an outward expression of that belief. The hijab must pass the essential religious practices test since it is a form of religious expression. That's issue 1. Okay. There is a contrast between conscience freedom and religious expression. Conscious freedom is something which is inside your heart. Okay. The state has no control over your heart. You are a God-loving person, you are a God-fearing person, and this is something between you and God. Or even your nearest relations do not have any idea about it. What is inside your heart? What feelings you have for the God? This is conscious freedom. And the court was trying to say that religious expression is very different from this. Because conscious is an internal belief, while religious expression, it's an outward expression of that belief. And so far as this hijab is concerned, it will have to pass the essential religious practice test. Okay. Issue 2. Now, baat just baat tum says, in our college and even in our university, girls used to wear hijab and no one ever said anything to them. That is the question. Baat just baat tum. Now, please tell me that since anybody did not say anything to them, why suddenly this issue has been raised now? Sridhar says they should have included in their prospectus, right, cause many such schools does it beforehand. Exactly. See, I have studied, and let me tell all my students today, I have, studied in so many schools. I started my schooling in a Muslim school. Then I went to a Christian school. Then I went to a Hindu school. And then I went to a convent school. Okay. And I have seen diversity of things in my country, in my life till now, at least in my school life. Okay. When I used to visit the Muslim school, there used to be some verses from Holy Quran in the morning assembly. When I visited the Hindu school, I used to recite bhajan every morning in the morning assembly, in the school assembly. When I started visiting the convent school, I used to recite those English prayers in the school assembly. So the question is that I have come across so many diversity of cultures, and I have seen that. The question is that whenever I used to visit a particular school, they used to issue a prospectus beforehand. When I visited the Muslim school, they issued a prospectus beforehand that these are the rules and regulations of this school and you are not supposed to do this. These are the do's and don'ts. When I started visiting the Hindu school, I was not allowed to, do so many things being a Muslim. And I accepted it. Because as a democratic citizen, that's what I have been brought up like. Okay, I have been like, tarbiyat aisi hui hai. In a secular country, in a religious tolerant country, I was taught to be religiously tolerant. Okay, I was brought up like that. So I never used to behave like a Muslim boy in my Hindu school, and I never did that in the convent school also. I used to behave like a school student like everybody else was. And it was not only me, there were so many other people like me. When Hindu students used to visit Muslim schools, they used to behave the same way. The question was that that's what the religious tolerance is. And that's what we have been brought up like. Isn't it? The issue is that whenever this religious tolerance came before us, we already knew of it beforehand, because we were already told about these do's and don'ts beforehand while our admission process was completed. Then it was our choice to go ahead with our admission or withdraw our candidature from the school. That was the question. Now suddenly the school just a day back allowed hijab in the university, and suddenly it prohibited the very next morning when the girls visited the school, the college. That is the question. Why such a sudden startling prohibition? That is the question. Trida says they should have included in their prospectus. Aditya Prakash, the issue is raised because of election. This is a fact whether someone expressly agrees or not. Okay, let's not get political. Now, wearing the heads, exactly, through the most of the convent schools, I must say that almost every school does this. Almost every school does this beforehand. Now, the biggest blunder on the part of the college was that it came out with a startling prohibition. It made a splash suddenly without any notice beforehand. Now, wearing the headscarf, the issue to wearing the headscarf is not an essential religious practice according to the court. It was not entitled to protection under Article 25. The hijab is not a religious practice according to the court. It is rather a cultural activity. The hijab developed as a means of ensuring women's safety, and it had a connection to the socio-cultural conditions that existed at the time the Quran was written. It cannot be considered a fundamental part of religion. This is what the judgment of the Karnataka High Court is. Furthermore, even if the court agreed that wearing the hijab constitutes an essential religious practice, the court ruled that the practice would only be protected by the constitution if it did not interfere with the constitutional principles like as equality and dignity. A threshold requirement for constitutional protection is that a practice must be an essential religious practice. The practice of wearing the hijab, on the other hand, does not breach this line in the circumstance. This was the judgment on observation of the Karnataka High Court on the second issue. Okay, that the hijab constitutes an essential religious practice. Okay, hijab constitutes an essential religious practice. Issue third, the court ruled that the hijab prohibition in public schools did not infringe their constitutional right to freedom of speech and expression under Article 19(1)(a). The court cited a worldwide agreement that uniforms and dress regulations can be enforced in educational institutions because it is religion neutral and universally applicable to all students. The state government's enforcement of a clothing code is a legitimate restriction that does not violate constitutionally protected rights. It was pointed out that the dress code really encourages secularism. The Muslim students were also claiming a breach of their derivative rights, not their substantive rights, according to the court. The right to select The right to select what one wears is an element of one's autonomy and expression, according to the court. This, however, must be subject to reasonable limitations. In certain public places, such as schools, freedom may be limited in order to maintain order and decorum. Now, they have categorized the schools and colleges as qualified public places where you cannot claim your freedom of expression and privacy. Okay, the court rejected the argument that pupils should be allowed to wear a headscarf that matched their uniform in color and pattern. This is due to the fact that if it is permitted, the school uniform ceases to be a uniform. That's right. I agree to this fact, but they must have issued this rule beforehand. And once they started with allowing the hijab inside the premises, they cannot do it now. Okay, issue 4. Now, Girish Shankar is saying that it is sticking to the fundamentals. I don't see how someone's wearing hijab is in violation of someone else's fundamental right of religion. Exactly. That's very true. If somebody else is wearing a hijab, if Muslim girl is wearing a hijab, why and how it is pestering others? That is the core of the entire debate. Why should I bother if some Muslim girl happens to wear if she does not wear any hijab? How and why should that disturb me and bother me? How am I connected with any other individual? That is the individual's right and completely his or her prerogative to do anything he or she likes to wear, anything he or she likes to wear. That is the question. Shall we says in Shaira Bano case, the age-old centuries practice was held unconstitutional and illegal. So in such cases, in context with the fundamental rights, the particular subject of practice is tested. Shall we? Let me tell you one thing very clearly. The Shaira Bano case is on the practice of triple talaq, the unconstitutionality of triple talaq. It was never found in Quran. And it has no comparison with the hijab judgment, because hijab is something which has been expressly ordered and commanded in the Quran. Okay. Issue 4. The state governments. Chidralekha is saying that who is deciding what is an essential and what is not? Why the court? Taran says wearing hijab doesn't incite any enmity amongst other religious groups. The sum and substance of the case is whether it falls under ERP or not. That's it. Then now the question is that who is going to decide the ERP? Who is going to decide the ERP? Judges are constitutional experts. They are not religious experts. If they have devised a doctrine called essential religious practice, on what grounds, what test, what formula are they going to apply? Now listen to me very carefully, all of you. What formula do they apply in determining that one particular activity forms an essential religious practice of a particular religion? What formula do they apply? And by what authority do they do that? Tell me, what formula do they apply? What is the formula? Tell me. There must be a formula to determine whether a particular activity squarely falls within the essential religious practice of one particular religion. Now what is the formula? Tell me. Stuti Sangamitra says that considering religion is an extremely personal issue, it stands upon me as an individual if I wish to practice it essentially or not. Okay, let's forget about this issue of privacy. Whether I want to practice some issue as an essentiality or not, that's not me and nobody else. It is only the Quran which has to decide what is essential and what not. There are express provisions in Quran regarding hijab. There are express provisions in hijab, express provisions in Quran regarding hijab. It's an express provision. There's nothing implied. And this judgment has come to the surprise of many of us, that how can the court ignore such express provisions in the Quran? The Quran has commanded to wear hijab expressly. There is no doubt about it. It's compulsory, it's mandatory, it's an essential religious practice in Islam. I don't know how these express provisions of Quran were categorically ignored by the Karnataka High Court judges. And the question that I want to raise here is, what authority does the court have in deciding the essentiality of any practice of any religion? Who is going to decide it? The question is, now these are legitimate questions. Okay, these are legitimate questions. Now the issue 4, the state government's order, which was issued on February 5th, was affirmed by the court. The order was made in accordance with the Karnataka Education Act 1983 according to the court. Under section 133(2) of the act, which allowed the government to give effect to the act's aims by making orders and constituting bodies like the college development committees, the government has the ability to prescribe a dress code. The court declined to order a disciplinary investigation of the principal and teachers of the government PU college, where students were originally forbidden from wearing the hijab. The petition demanding that the court direct an investigation into the involvement of Islamic organizations in the rallies against the hijab ban was dismissed by the court. Now there is doctrine of proportionality. Just like Aditya Prakash said in the very beginning that the fundamental rights are not absolute, that's very true. No fundamental right is absolute. Just like power corrupts and absolute power corrupts absolutely, and that's how the freedom also led people go astray, and absolute freedom would it's going to ruin the society. Certain reasonable regulations and reasonable restrictions are necessary to control the society and regulate it in a proper manner. That's very true. No fundamental right is absolute. Every fundamental every fundamental rights comes with a set of reasonable restrictions. That's very true. Even Article 25 starts with restrictions, and then it talks about the religious freedom. It says subject to public order, health and morality. Okay. Subject to public order, health and morality. Okay. Now, the fundamental rights, live, learn, law says, but our country is run by constitution, not by Quran. Then why was the Quran brought in between? The question is, it should not have been brought in between. It should not have been brought in between. Why it was said that there is nothing like hijab in Quran? If this country is not run by Quran and it is run by constitution, that's true. Even I know that. Everybody else knows this. And this country should be run by the constitution only. But the question is that if Quran has become so irrelevant for the people of this country, then why was the issue of Quran and the name of Quran was brought in the judgment of the Karnataka High Court? Why it was discussed by the judges on the bench even bothered to discuss the provisions in the Quran? Why did they discuss about it? If they are saying that there is no express provision, then every person has this right of rebuttal that whatever they say is absolutely wrong, and there is an express provision of hijab in the Quran. That's it. Okay. Our country is secular, which means that it respects all religions, so being run by Holy Quran is not relevant here. Nobody is saying that. Exactly, Zenia. Nobody is saying that this country should be run by or it is run by Quran. It cannot be run by Bhagavad Gita, it cannot be run by Guru Granth Sahib, it cannot be run by Bible, it cannot be run by Quran, because India is the only country of its kind which is so diverse in religion. This is the only country in the world of its kind. There is no other country on the face of the earth like India. But the whole question is that if it is not run by any religious text, then why was this discussion about religious text was brought in between? The matter should have been solely decided on the basis of constitution. Why did the judges bother to discuss anything about the essential religious practice? Why did they bother to say that hijab does not form an essential religious practice of Islam, despite the fact that it actually forms an essential religious practice in Islam? There are express provisions in Quran about hijab. And also, as Chitralekha raises a very pertinent question, that judges may be very good constitutional experts. There's nobody above the judges of the High Courts and the Supreme Court in deciding the constitutional provisions and their, various discourses and trajectories. But the question is that are they equally competent to discuss anything about any religious text? Can they discuss any provision about Bhagavad Gita? The Supreme Court, said it's not only about Islam. The judiciary has been diluting the essence of every religion in the name of essential religious practice. It said that the Tandav dance, the Tandav, is not an essential religious practice in Islam. It's not an essential religious practice of Hinduism. It's not an ERP of Hinduism. Now, this is slowly and gradually, this is dilution of religions and nothing else. I agree that school uniforms should be strictly prescribed. And there should not be any compromise on this issue. I agree this. But this should have been decided beforehand. You cannot, until a day before, you cannot allow this. You allowed this, and until just the very next day, you disallowed it. You prohibited. You in fact prohibited the entry of Muslim girls wearing hijab wearing girls on the premises. And hijab is not solely attributable to Islam. It is equally attributable to Hinduism. It is equally attributable to Christianity. It is equally attributable to Sikhism. Even the Sikh women, they cover their heads. The Christian women, they cover their heads. Look at the Vedic society, study the Vedic society and study the essential core of Hinduism. You would come to know that even the Hindu girls used to cover their heads. This is not something which is solely attributable to Islam. Okay. Which says that carrying of kirpan is squarely covered under the profession. Even if it is expressed in Quran that hijab is essential practice in Islam, then also it should not be allowed by the educational institutions. Then again the same question. I am saying that it should not be allowed by educational institutions. My batchmates were never, my Muslim batchmates, they were never allowed to wear hijab in my convent schools or any other school. They were not allowed to wear hijabs. But the question is that they were told this beforehand. They were told this beforehand. The dress code was not changed suddenly with an express prohibition that hijab is not allowed. That until yesterday, I was, as a Muslim girl, allowed to visit my college wearing a hijab. And today, the very next morning, when I visited my college, I was not even allowed to enter the premises only because I was wearing a hijab. This is ridiculous. This should not have been done. Any college, any school, or any educational institution should prescribe these do's and don'ts beforehand. You cannot do this suddenly. And you should give the candidates a choice to seek the admission or to withdraw their candidature from the educational institution. Then it should be complete, should be a complete prerogative of the individual and the candidate to whether to take admission and go ahead with the do's and don'ts while accepting the do's and don'ts of the institution. Or if he wants to adhere and stick, strictly to their religious practices, then they must have the freedom to do that as well. The question is this: I'm saying that, and again I'm saying, see, the uniform code should not be compromised in any manner. Should not be compromised. Only the uniform should be strictly allowed inside the schools. No other religious dress code should be allowed. No other religious code should be allowed. Dress code should be allowed inside the educational institutions. But I'm saying this, that every institution should do this beforehand. You cannot make it an issue to win the elections. That's it. I'm saying this, that's it. The second issue is doctrine of proportionality. I was saying that, as Aditya Prakash commented, that fundamental rights are not absolute. Every fundamental right comes with a set of reasonable restrictions. Now these reasonable restrictions, they are used in accordance with the doctrine of proportionality. Or what is the doctrine of proportionality? Doctrine of proportionality is that as and when some such circumstances arise, that when the government thinks it feasible to curb or muzzle any fundamental right, then that fundamental right cannot be curbed absolutely. It should be muzzled, it should be suppressed only in a proportion which is sufficient for that policy to exist. Okay. For example, if government comes out with a policy or law which is essentially needed in a society, and that law exactly, Aditya, very good. That's what I was about to say. It would be better if the High Court should have allowed the practice till completion of a complete session, and from the next session for the new admissions it should not have been allowed. That would have been a proper act. That's very good. From the very next session, the newcomers, the new admissions should have been told this beforehand, and they should not have been allowed. They should have been told that you are supposed to follow the school uniform strictly, and you are not allowed to wear any religious dress here inside the premises. That would have been the most appropriate thing on the part of the institution. Very good. But they should at least have allowed till the completion of a session. See, any girl This is very, we really can't feel the pain of a girl who wears hijab, who does not want to open her head. This is really painful for her. This is really painful for her. We should understand the religious sentiments of the other individuals also. We should have some respect for the religious sentiments of the other individuals also. We can't be so ignorant. We live in a religiously tolerant, civilized society. We are not supposed to behave this way. We are not supposed to behave this way. We should rather, do it in the most amicable manner. There's a way of doing it. If something is wrong from ab initio, then why it should be allowed? Then what was the authority? What were the authorities doing since beginning? Were they sleeping? What they were doing? If it was void ab initio, what were they doing up till now? They were so ignorant. Such a self-loathing institution it was, I must say. Exactly. The fact is that election cannot wait for the completion of session. That is the fact. I was saying that doctrine of proportionality is very, it's very genuine. That, for example, a government comes out with a policy or a law. A government comes out with a policy which is desperately needed in a society. And that law or policy happens to violate any fundamental right. Any fundamental right. Now, you assume the situation. Just listen to me very carefully what I am trying to explain you. Doctrine of proportionality is this, what I am trying to explain you through an illustration, that, for example, if a government comes out with a law or a policy which is desperately needed in a society, and that policy or law happens to violate any of your fundamental right, okay, then the court will decide that how far it is curbing the fundamental right. Okay, no policy or law curbs the fundamental right absolutely. They are curbed or they are suppressed only in proportion what is needed. If the fundamental rights are suppressed in a proportion more than what is required, that becomes unconstitutional. Okay, every restriction is allowed so far it is suppressing the fundamental right in the right proportion. And if it is doing more than that, then it becomes unconstitutional. So such prohibitions should not come in an absolute form. They should be allowed up to a certain extent, and they should be suppressed up to a certain extent, only up to an extent what is needed, what is sufficient. Okay, that is doctrine of proportionality. Every time, for example, you have freedom of speech and expression. But every time we cannot enjoy a freedom of speech and expression. That is not an absolute freedom. We have a set of reasonable restrictions under Article 19(2) of the Constitution, and every time what happens? We cannot comment on the sovereignty of India, which is something which is dangerous for the sovereignty of India. We cannot say anything which is, which is harmful for the security and law and order in the society. Okay, we have freedom of speech and expression. That means our freedom of speech and expression is suppressed up to an extent what is actually appropriate and what is actually needed. But what if in the name of law and order, what if in the name of decency and morality, tomorrow the state curbs all your freedom of speech and expression absolutely? Will then it be all right? No. This is going to be a violation of doctrine of proportionality. Doctrine of proportionality allows the state to suppress your fundamental rights only in an exact proportion what is needed for a law or policy to sustain. And if the government is trying to suppress those fundamental rights beyond that, under the guise of that law, under the pretenses of that policy, then that, that extra suppression is unconstitutional. Okay, according to the doctrine of proportionality. And so far as this essential religious practice is concerned, I must say that the court should not look into the religious text. It should only look into the constitutional provisions and find out that if somebody's religious practice is not harming the fundamental rights of the other people. Okay, and do you know when this religious practice is applied? Do you know when this essential religious practice is applied? Do you have any idea? When does this essential religious practice is applied? Any idea about it? Any idea about it? When does this essential religious practice is applied? Now there are two situations, let me tell you very clearly. There are two situations. The two situations are that in the first situation, the fundamental rights of the citizens come in direct conflict with the law and policy of the state. That means it is the rights versus the states. The first situation is rights versus the state. What is the first situation? When the fundamental rights of the citizens, they come in direct conflict with the law and policy of the state. That means it is fundamental rights versus the state. Okay. Now I am explaining you. There are two situations. The first situation is when the fundamental rights, when the fundamental rights versus the state. The second situation is that when the fundamental rights of one group of individuals comes in direct conflict with the fundamental rights of the other group of individuals. Okay, when it's rights versus rights. Okay, when it's rights versus rights. Okay, there are two situations. Are you getting my point? Have you understood the two situations? The first situation is rights versus a state policy or state law. The second situation is rights versus rights, when in group rights of fundamental rights of one group of individuals is in direct conflict with the fundamental rights of the other group of individuals. That it means rights versus rights. Are you getting my point? Okay. The doctrine of in the first situation, when fundamental rights are in direct conflict with the state policy or the state law, essential religious practice is not applied. It's not applied. It should be applied. What should be applied then? Doctrine of proportionality. In order to assess the constitutionality of the state law or state policy or state action or any executive or legislative action, doctrine of proportionality should be applied to find out how far it is important to bring this particular law or policy and how far it is feasible, in what proportion it is feasible to suppress the fundamental rights. So in the first case, doctrine of ERP is not applied, but doctrine of proportionality is applied. And in the second case, when it is rights versus rights, it is rights versus rights when the fundamental rights of two different groups of individuals are in direct conflict with each other, then the judiciary should apply the ERP, the essential religious practice, to find out that if the religious freedoms of two group of individuals are violating each other's rights. If I am, for example, exercising my freedom of religion, it is violating your freedom of religion, and if you are exercising your freedom of religion, it is violating my freedom of religion. Then in that case, it's rights versus rights. Then in such cases, the judiciary should apply the doctrine of essential religious practice to find out that which religious practice of which group is an essential religious practice. Only that practice shall have primacy over the religious practice of the other group. One right has to be suppressed in a particular proportion only because the other group right forms an essential religious practice of that religion. Okay, which group right is more important? In such cases, ERP is applied. In the first case, proportionality, doctrine of proportionality is applied. In the second case, doctrine of ERP is applied. What happened in this case? This case was the second case or the first case? Tell me. This was the first case. It was rights versus the state action. The wearing of hijab was not affecting any other group of individuals' rights. This was not affecting the rights of any group or any other group of individuals. Now this was criticized and prohibited by a state action. So it was rights versus a state. And the Karnataka High Court should have applied doctrine of proportionality rather than doctrine of ERP. Are you getting my point? So that's how this, these are the lacunas which have not, this is not what I am saying. The newspapers, the magazines are full of these kinds of criticisms. If you read those articles, you would come across. This is not what I am saying. This is what the, big legal people from the legal fraternity are saying. Okay. This situation of hijab case falls in the first situation. It's rights versus the state. And the court should have straight away applied the doctrine of proportionality and how far it is feasible to bring this law, to bring this prohibition. And if it is feasible, then it should be applicable by what time and in what manner and in what proportion it should suppress the fundamental right of wearing the hijab. Right? That's it. Now you must be having a lot of questions and most of the things to add and complement to supplement it to what we have discussed today. Then you are most welcome to do that. Have you understood the two situations that I explained to you? Any question, anything you want to add? Okay, then let's end this. I'm signing off, and let's meet tomorrow with another case. Okay, till then, all the very best and bye bye.